ACLU. I would especially like to thank Professor Devlin for moderating today's debate, as well as Mr. Levy, Professor Ngov, and Professor Pujol for joining us to debate the constitutionality of the individual mandate to the Affordable Care Act. Mr. Levy is chairman of the Cato Institute, the country's leading libertarian think tank. Professor Ngov teaches constitutional law here and is both the faculty advisor for the American Constitution Society as well as the ACLU. And Professor Pujol also teaches constitutional law here, and today will be his second time participating in the professor's debate. During the debate, if you end up having any questions that you'd like answered, please write them down. We have some note cards laying out, and then once you're done, just send them to the aisles, and there'll be a student who will come by and pick them up. Near the end of the debate, there will be time for students' questions to be answered by the panel, a couple of them. Before we begin, Nick Primrose is going to take a few minutes to explain what the federal mandate is and the 3 constitutional challenges. Thank you.
All right, thank you guys for attending today. We're here today to hear a debate on the minimum essential provision, otherwise known as the individual mandate. And as you may or may not know, the Supreme Court will hear oral arguments on this exact issue a week from today. But you're all going to hear the exact same issues and challenges that the 9 justices will hear next Tuesday. So I'd like to set the stage for you. What is the individual mandate? Now, the debate about providing health insurance to every citizen has been around for more than 60 years. This isn't a new issue. But it was on September 9th, 2009 that President Obama spoke to a joint session of Congress with the latest attempt at achieving this legislation. You fast forward to March 23rd, 2010, President Obama signs into act the Patient Protection and Affordable Care Act. Now, it was during that speech to Congress that President Obama said, and I quote, "Under my plan, individuals will be required to carry basic health insurance just as most states require you to carry automobile insurance." In 26 U.S. Code Section 5000 AA states, quote, "An applicable individual shall, for each month beginning after 2013, ensure that the individual is covered under minimum essential coverage." Now, there are 3 exceptions to this. There's a religious exemption. If you're an illegal alien or if you're incarcerated, you don't have to buy this minimum coverage. But if you don't fall under one of those coverages, you get a penalty. And the penalty, which achieves its maximum value in 2015, is $695 or 2.5% of your gross adjusted income, whichever is the greater of the 2. So now that you kind of know the basics about what the individual mandate is, requiring you to purchase a bare minimum essential plan that the Department of Health and Human Services creates, what should you expect to hear? Well, there's 3 constitutional arguments really to the individual mandate. There's under the Commerce Clause, under the Necessary and Proper Clause, and under the Taxing and Spending Clause. So first, you have Article 1, Section 8, Clause 3, the Commerce Clause. It's only 16 words long. It says that Congress shall have the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. So the question here is requiring citizens to purchase health insurance a valid exercise of the Commerce Clause? Does purchasing or the lack of purchasing health insurance have a substantial effect on commerce? Now, the second argument, Article 1, Section 8, Clause 18, the Necessary and Proper Clause, that Congress can make any law that's necessary and proper to carry out the execution of the foregoing vested powers. So the question here is requiring citizens to purchase health insurance necessary and proper in achieving Congress's goals? Or does Congress even have the authority to force individuals to enter contracts with private insurance companies? And the last challenge, Article 1, Section 8, Clause 1, the Taxing and Spending Clause. Congress has the power to lay and collect taxes and to provide for the general welfare of the United States. The question here is the individual mandate even a tax, or is it a penalty? Does it fall under this? This is what you will hear today. So members of the audience, it's your chance to be the Supreme Court. In a moment, you will hear the reasons why these clauses are so important to determining the constitutionality of the individual mandate. So at this time, Professor Benland, without further ado, the floor is yours.
Good afternoon. It's great to see so many of the faculty here, as well as so many of the smartest students up here, like in this room. Here's the format of the debate today. Mr. Levy will have 20 minutes. Can you is my line working? It doesn't feel like it's working, but if I set it like this, okay, is this better? Yeah. Okay, good. You heard the part about the smartest. Mr. Levy will have 20 minutes to present why the individual mandate is not constitutional. Then Professors Pujol and Ngov will have 20 minutes to present why the individual mandate is constitutional. Then Mr. Levy will have 7 minutes to rebut the professor's points, and the professors will have 7 minutes to rebut Mr. Levy. Then we're going to open it up to the questions that you will have written down on the cards. We'll gather those here, and we'll put some of those questions to our panelists. So that being the format, I will now turn the floor over to Mr. Levy, and we have a timekeeper, Ronaldo Cartaya, will literally be the moot court style timekeeper and show the speakers how much time they have remaining. So Mr. Levy,
it's great to be with you. The central issue in this case is even more important than Nicholas stated, and it is whether there are any remaining limits whatsoever to the exercise of federal power. Of course, the context of that issue is whether the Affordable Care Act, Obamacare, is constitutional, including its unprecedented mandate that individuals have to buy health insurance or pay a penalty. Now, why the mandate? Without the mandate, said President Obama, the rest of the legislation falls apart. The mandate was intended to address a very real problem. People get sick. Most people get their insurance through their employers. When they get sick, if they lose their job, they find themselves sick and without an employer, and therefore without insurance. When they go to get new insurance, insurers, rationally, are unwilling to insure people who are already sick. You do not insure houses against fire if the fire has already been started. And so, Obama decided we need to fix that problem. And the way he decided we're going to fix that problem is require the insurance companies to cover pre-existing conditions. And the insurance companies may not charge any more for somebody who has a pre-existing condition than for somebody who does not. The insurance companies, I think, rationally responded, look, this is going to be a real problem for us. After all, our customers are not stupid. If they know that we have to cover them when they get sick, why in the world would they take out a health insurance policy when they're in good health? There's no sense in paying premiums if you know very well that once you get sick, the insurance company has to cover you and can't charge you any more money. President Obama's response, don't worry about customers waiting until they're sick. We're not going to let them wait. We're going to force them to buy insurance. And if they don't buy insurance, we're going to require that they pay a penalty. So this mandate is simply a subsidy to the insurance companies so they can afford to cover pre-existing conditions. It's an unprecedented mandate, untested in the courts. When it was last proposed in the context of Hillary care, this is back in 1994, here's what the Congressional Budget Office wrote, and I'm quoting. The government has never required people to buy any good or service to the condition of lawful residence in the United States. And yet that is precisely what Obamacare will do unless and until the Supreme Court says otherwise. As you've heard, the proponents of Obamacare cite 3 clauses: the taxing power, the Commerce Clause, the necessary and proper clause as their constitutional authority. The taxing power rationale has garnered support from only one court, so I want to dispense with that argument up front and quickly. The purpose of a tax, as you probably know, is to generate revenue. By contrast, the insurance mandate exists solely to coerce people into buying health insurance. If the mandate worked perfectly, it would generate 0 revenue, not 1 dime of revenue. So the assessment is not a tax, it is a penalty. Only legal acts can be taxed. For example, cigarettes. If Congress makes something illegal, for example, heroin, or for example, not buying health insurance, the government's recourse is punishment and not taxation. Moreover, Congress wrote tax in an earlier version of Obamacare and then stripped that term and replaced it with the word penalty in the version that passed. And elsewhere in the Obamacare legislation, the word tax is used so that Congress knew very well how to specify tax when it meant a tax and how to specify penalty when it meant a penalty. Obama himself, and in the legislation, has cited the Commerce Clause and not the taxing power as its constitutional authority. Apparently, Congress did not want the scrutiny that attaches to multi-billion-dollar tax increases, especially after the president had promised over and over again that there will be no new taxes on the middle class. So it's quite clear that this mandate imposes a penalty and not a tax. And so my focus today is going to be on the other two clauses, the Commerce Clause and the Necessary and Proper Clause. The threshold question under the Commerce Clause is whether Congress's conceded power, laid out right there in Article 1, Section 8, to regulate commerce among the states, whether that power can be extended to activities that are not commerce and that are not interstate. And if no seems like a self-evident answer, it's because you haven't been following the Supreme Court over the past 7 decades. The most important case was the 1942 infamous case where it was Filburn, and Mr. Filburn grew wheat on his own farm, all within one state. He didn't buy it, he grew it. He didn't sell the wheat, he ate it, or he gave it to his farm animals. The Roosevelt administration decided that the price of wheat was too low. And the way to fix that is to reduce consumption. To reduce production. And so Roosevelt said to Filburn, you have to quit producing so much. Filburn says, under what authority? Roosevelt says, regulating interstate commerce. Filburn says, well, guess what? It isn't interstate. It's on my farm in one state, and there's no commerce. There's no buying and there's no selling. I'm growing this stuff and I'm eating it. The Supreme Court took a look at the case and essentially said, Filburn, you just don't get it. If you weren't out there growing this stuff, you would have had to buy it. And if you weren't eating everything you grew, you would have had some left over to sell. So by growing and eating instead of buying and selling, obviously you're having an impact on the supply and demand for wheat. And when we take into account all the other folks that are doing the same thing, there's going to be an impact on interstate commerce. That opened the floodgates through which the regulatory state was ready to pour, regulating anything and everything under the rubric of the Commerce Clause. Now, understand the Commerce Clause, we have to define some terms. Commerce is the first. Commerce is buying and selling, the exchange of goods and services. Buying and selling. Now, in Wicker v. Filburn, the court said the authority to regulate commerce extends beyond commerce. It extends to activities that are not commercial. They're economic acts that in the aggregate have a substantial effect on commerce, even though they themselves are not commerce. So the important next term we need to define is an economic act. What's an economic act? It's far broader than commerce. It includes growing, as in Wicker v. Filburn, mining, manufacturing, distributing, consuming, and of course buying and selling, that is commerce itself. So an economic act is far broader than commerce, and Wicker v. Filburn does establish that Congress can control, can regulate economic acts if, in the aggregate, they have a substantial effect on commerce. But Congress may not regulate non-economic acts. And it took them 50 years to decide that in the 1995 case law, the United States versus Lopez. The issue is whether Congress could regulate under the Commerce Clause the mere possession of a gun within 1,000 feet of a school, and the Supreme Court said no, possession is not an economic act. There is no growing, no mining, no manufacturing, no distributing, no consuming, no buying, and no selling. It's not an economic act. Congress may not reach economic acts. So here we have a case where we do not have an economic act under Obamacare. As a matter of fact, we have the conscious decision not to engage in an economic act. And furthermore, we don't have an interstate market. As you may know, under law, it is illegal to purchase health insurance across state lines. So there's no market and there is no commerce. Essentially, the mandate is regulatory bootstrapping of the worst sort. First, Congress forces you to engage in commerce and then proclaims that you can be regulated because you are engaged in commerce. And if Congress can do that, it can do pretty much whatever it wishes. In my view, even if Congress could force me, or could force Mr. Filburn, for example, to decrease his wheat production, doesn't mean it could force me to go to the grocery store and buy bread in order to subsidize Mr. Filburn's wheat production. The litmus test is economic activity. A mental decision not to engage in commerce is not an economic act. In that respect, it's no different than a decision not to work. And at least so far, the Supreme Court has not been able to compel that we go to work. Neither decision can be regulated simply because you have a non-act, and if it was converted into an act, then in the aggregate it might have a substantial effect on interstate commerce. The Virginia judge in the Obamacare case put it this way, very succinctly. Quote, the subject matter must be economic in nature and must affect interstate commerce and must involve activity. Thought processes are not subject to regulation. Now, defenders of Obamacare point to an opinion by a Sixth Circuit judge in another Obamacare case in the appellate courts, Jeff Sutton, conservative judge. And he wrote, self-insurance. Now, we know self-insurance is not buying insurance. That is insuring out of your own pocket. He said self-insurance and commercial insurance, of course that's buying insurance, are two forms of action for addressing the same risk. Now, with respect, Judge Sutton is wrong on two counts. First, self-insurance simply equates to self-financing, which simply means we don't do anything until a bill comes due. And when the bill comes due, we pay it. And that, of course, is the same thing we do with respect to every cost. So, if self-insurance can be regulated, then every single expense that we engage in can be regulated. Second, if a decision not to buy health insurance is, as Judge Sutton would have us believe, an economic act that the government can ban, then what about other so-called acts, many of which are health-related? For example, can the federal government mandate that we join a gym instead of self-exercise? Can the government mandate that we join Weight Watchers instead of self-diet? That we attend adult education courses instead of self-educate? Now, plainly, that cannot be the state of our law. Finally, Obamacare supporters argue that requiring health insurance is no different than requiring the advanced purchase of health care. The argument goes like this. Nearly everybody ultimately consumes health care. And consumption is clearly an economic act, as it was in Wickard v. Filbert. Why then wouldn't the Commerce Clause allow the federal government to direct that health care be purchased now by buying an insurance policy instead of later when the medical bill comes due? In other words, buying insurance is just a timing decision. It's about when and not whether to engage in the purchase of health care costs. Judge Vincent in the Florida case was not convinced. Virtually all forms of insurance, he pointed out, represent timing decisions. So we pay up front for car accidents, for loss of life, for burial costs, for disability, fires, floods, hurricanes, and on and on. Only a federal government of unbounded powers can mandate that every American has to insure against all of those risks. Never has the Commerce Clause been stretched to such lengths, and that's why the proponents of Obamacare had to have a fallback position, and that fallback position was and is the necessary and proper clause. So suppose the mandate to buy health insurance does not qualify as a direct regulation of interstate commerce. Even so, the administration argues, the Constitution authorizes implicit powers which provides that Congress can, quote, make all laws which shall be necessary and proper for carrying into execution its other legitimate powers. Forcing Americans to purchase an insurance product that they don't want is ostensibly permissible, but only because the mandate is a necessary and proper means, so the administration tells us, of regulating the national health care system, not the health insurance system, but the health care system. That assertion is based on two underlying arguments, both of which are incorrect. First, the mandate is said to be necessary because its elimination would perpetuate the problem of the uninsured. What's that problem? It is that without a mandate, responsible insured consumers end up paying the health costs of irresponsible uninsured consumers who show up at the emergency window and get health care and can't pay for it and are not insured. This kind of cost shifting by the uninsured is not, however, inevitable. It arises only because we've passed another law, and that law compels doctors and hospitals to serve all comers. Now, maybe it is that that law is a good idea. If so, we ought to have a straightforward and transparent tax to pay the bills uncompensated emergency care, not a hidden cost on insurance companies who pass it along to responsible consumers of health care, and we end up subsidizing the giant insurance companies so they can afford to pay these costs. Furthermore, these costs, that is uncompensated emergency care, they arise only if a person gets sick, if he seeks medical care, if he can't pay, if he has no access to funds from his own pocket, his family, his friends, or private charities. And that situation can be much more efficiently addressed if and when it occurs, for example, by mandating community service for emergency patients who show up and get health care and do not pay for it. Even if almost everyone ultimately consumes medical care, not everyone gets free medical care at public expense. And paradoxically, the people who are most likely to show up for emergency care and not pay the bills, those tend to be people who do not have the financial means to pay for the bills. They indeed are exempt from the mandate. They are not covered by the mandate. So the very thought that they will be incentivized to buy health insurance is ridiculous. They are not covered by the mandate. And to put this in perspective, uncompensated care in the United States accounts for $48 billion a year. That's not a trivial number, but it's about 2% of the $2.4 trillion that we spend each year in healthcare expenditures. Meaningful, but scarcely a crisis. Moreover, an insurance mandate does not eliminate this cost. The cost of uncompensated care is simply transferred to insurance companies, and they recoup their outlays by selling mandated policies to individuals like us who may not wish to own them. And in fact, what you can count on is that total health care costs are going to increase as more persons become insured. That's what in the insurance industry they call moral hazard. People tend to behave differently when they know the costs are not coming out of their wallet. They're coming out of the insurance company's wallets. Insured persons will demand more medical service than persons who pay their own way. And that higher demand means a higher price for medical service. It is no accident that the cost of LASIK surgery and the cost of cosmetic surgery has gone down, while the cost of MRIs has exploded. The reason LASIK surgery, cosmetic surgery is not covered by insurance, MRIs, of course, are covered by insurance. Obama's mandate forcing more people to get insured, even people that don't want it, is going to make matters worse. It will inflate medical costs. It is not only unnecessary, it actually exacerbates the problem. Now, I can see there are costs imposed by some people, that is, people who are not insured. They do impose costs on others when they end up consuming health care costs and don't pay the bill. But so do non-purchasers of lots of other products that could potentially reduce health care costs. For example, nutritional foods. People that don't buy nutritional foods impose costs on others. What about people that don't buy exercise gear? What about people that don't get enough preventive medicine? Does the government also claim authority under the Necessary and Proper Clause to coerce the purchase of all of those products? And if that answer is yes, then why stop with health care? What about defaults on credit cards and defaults on mortgages? They drive up interest rates for all of us. They impose substantial costs on non-defaulters. Can the government compel that we have credit card insurance or mortgage insurance? Now, the administration has a second rationale for invoking the Necessary and Proper Clause, and it's no more convincing. Namely, it is essential for everyone to be covered for pre-existing conditions. That's the problem that I mentioned at the outset, and the insurance mandate is necessary to accomplish that goal. Once again, Judge Vincent in Florida saw through this, I think, sophisticated argument. The mandate is artificially necessary, he wrote. It's required only because Congress itself created the problem and left no alternatives. Here's what he wrote, quote, "The individual mandate is actually being used as the means to avoid the adverse consequences of the act itself, namely the requirement to cover pre-existing conditions. Under such a rationale, the more harm the statute does, the more power Congress can assume for itself under the Necessary and Proper Clause." And then finally, consider the remaining term in the Necessary and Proper Clause, the requirement that a regulation be proper. Chief Justice Marshall set the standard in McCulloch v. Maryland. A regulation that is proper if it does not violate established rights and it is consistent with the letter and spirit of the Constitution. There have been only a handful of articles, scholarly articles, that have addressed the legal meaning of property, but Judge Vincent in Florida had no trouble applying Marshall's guidepost. Quote, the individual mandate cannot be reconciled with a limited government of enumerated powers. By definition, it cannot be property. So imagine that President Obama goes to the food industry and says, you know, obesity is a huge problem in this country. It's driving up medical costs. And you guys are the cause because you're selling too much chocolate. So you're going to have to stop selling so much chocolate. And the food industry says, well, you know, we're making a lot of money on chocolate. And Obama responds, well, don't worry about that. Just raise the price of celery, and you will make up what you've lost in the sales of chocolate. The food industry rationally responds, you know, we're not selling a lot of celery at the existing price. The chances are we're going to sell even less at the higher price. And Obama's response finally is, don't worry about people not buying celery at the higher price. We will force them to buy celery. And if they don't buy celery, they will have to pay a penalty. Now, this is the exact equivalent of what's going on with the insurance mandate. Would the mandate to buy celery or pay a penalty be a legitimate regulation of interstate commerce and interstate health care? My answer, not constitutional. Our current Supreme Court might disagree, but there is no precedent that dictates that outcome, not even Wickard v. Filbert. The individual mandate could extend the dominion of the federal government to virtually all manner of human conduct, including non-conduct. So here is the story of Obamacare and the mandate in a nutshell. First, the penalty for not buying health insurance is not a tax. Second, the power to regulate interstate commerce extends only to economic activities. It does not permit Congress to compel activities in order that Congress be able to regulate them. Third, the mandate is not necessary. It merely circumvents problems that would not exist if not for the Obamacare itself. And fourth, the mandate is not proper. It cannot be reconciled with the framers' original design for a limited government of enumerated powers. Thank you.
Following those 20 powerful minutes, we have Professors Pujol and Ngov, who have 20 minutes equally, to present why they believe the individual mandate is constitutional.
Great. Professor Ngov and I have agreed to just divide our time, and I'll just begin with a short overview. And I want to say, you know, a lot of what Dr. Levy had to say are very good policy arguments. But those arguments had to have been made in the floor of the Senate or the floor of the House, not in a courtroom. We cannot allow judges to, in essence, circumvent our democratic process. If you don't like Obamacare, vote for Mitt Romney. That's the end of it. We can't allow judges to decide these matters for ourselves. Now, I provided an overview here, and I think Dr. Levy did an excellent job of describing the freeloading problem, right? This idea of uncompensated care. I would also add there's a second freeloading problem, this idea of adverse selection. This idea that, it's just not profitable for insurance companies only to insure bad risks, right? The law does require insurance companies to insure everyone, including persons with pre-existing conditions. So we have two real serious problems. Now, this is critical to understand whatever law, and the ultimate question here, right, is does Congress have the power to do this, to impose an individual or minimum coverage mandate? And ultimately, the answer to that question is Congress solving a national problem? Now, I want to say that when we, and again, I won't add more to this because I think actually Dr. Levy did a great job in describing the freeloading problem, right? That people without insurance, in essence, expect the government, expect taxpayers to pay their medical bills. Now, well, what are different possible solutions? Now, Dr. Levy, right, I guess is arguing for the status quo, that we do nothing. Or like his solution of, well, maybe we allow people who impose uncompensated costs to do community service, right? But look at all the possible solutions to the healthcare problem, right? And at the far extreme, there's no doubt that Congress has the power, right, to create a national health service, to actually socialize medicine under its existing commerce and necessary and proper clause powers. Also, Congress could take perhaps less drastic, but just as bad from a policy perspective, a prohibition solution. Hey, if you don't have insurance, we're not going to require doctors and hospitals to provide you medical service, right? Congress could have done that. And again, there'd be no problem under the Constitution, under the limits of Congress's power. What Congress really did here was just an incremental step and say, look, either you get insurance on your own, or you pay a penalty or a tax, which would be the equivalent of what insurance would cost you. What Congress is doing is saying, look, no more free rides, no more free loading. Now, I submit to you, Professor Ngov is going to talk about the Commerce Clause, but I submit to you the ultimate question here is what I like to call in my classes a second-order question. The ultimate question here is, who's going to decide? Do we want, in essence, a committee of lawyers deciding for us what laws are good and bad, what laws exceed the limits of the Constitution? Or don't we want our elected officials, who we can hold accountable during the periodic election cycle? Don't we prefer our members of Congress and the President to make these decisions for us, because that's what we elect them for? And I have to say, the celery hypothetical, very entertaining, as were the other hypotheticals. But it's not a problem, right? Congress is not, for political reasons, right? We have a system that if they were to pass some egregious type of law like that, there's going to be a political price. Congressmen know that. They're rational actors as well, and that's why, that's the true check, the political process, the electoral process. But I'll end up my overview with this. If you still want to trust judges, if you think, in fact, right, judges are there to enforce limits on the Constitution, well, let's go to what our leading judge, Chief Justice John Marshall, who Dr. Levy cited earlier. And of course, the relevant language here, the most celebrated phrase in McCulloch v. Maryland, which a case we'll talk about later, is as long as the end that Congress is trying to accomplish is legitimate, right? As long as it's within the scope of the Constitution. And we'll argue what is within the scope and what is not within the scope, right? Well, then all means, which today we would say are at least rationally related, and that do not run afoul of any specific limit, such as, for example, within the Bill of Rights, right? Any means that are rationally related and that don't discriminate against an insular group, right, are constitutional. In fact, what's unprecedented was McCulloch v. Maryland, what Congress did there. Create a national bank which has no reference in the text of the Constitution, and Chief Justice John Marshall, in elaborating his test, said, no, look, we have to trust members of Congress. They make the decision, and if they get it wrong, that's why we have the political process, and that's why the American people ultimately elected Andrew Jackson, who was against the bank. So, applying what our great Justice, Chief Justice John Marshall said, we can apply it to Obamacare, right? The ends are to solve these free rider problems. Now, I'm actually persuaded by Dr. Levy, probably better ways of solving the problem that may not require a mandate. Maybe, in fact, Congress should have a more drastic national health care service. Maybe a simpler solution is allow doctors to deny coverage if people are not insured. But the key is that, what is the ultimate problem that Congress wants to solve? And if that problem is national in scope, then the means, if those means are related even rationally to the ends, according to Chief Justice John Marshall, according to 2 centuries of judicial precedents and judicial authorities, right, that action is constitutional. And I want to end on that point. What we're really debating here, I submit to you, is not whether Congress has exceeded its powers. Because if it has, we have an election cycle to deal with that. What we're really debating here is if the Supreme Court next week is going to exceed its powers if it decides to nullify a democratically approved law.
I'm going to stand because I'm afraid I'm so short you won't be able to see me out here. So, let me stand it. My discussion hopefully will persuade you in 2 manners. One, that your con law class was a worthwhile investment. And 2, that Superman falls under the minimum provision, healthcare provision. Raise your hand if you've ever had a moment where you did feel like Superman. Maybe like when you were 5 and you felt invisible. Have we had those moments? Okay, well, we'll talk about Superman in a minute. I'm going to address the Commerce Clause and also the taxing and spending power. First, beginning with the Commerce Clause. We know that the test, right? We can recite that. Hopefully you'll be reciting it for the bar. Instrumentalities, persons, and things traveling in interstate commerce, the channels, and those things having substantial effect on interstate commerce. I think we could fall under the second prong, which is persons and things traveling in interstate. But the most contentious one is what we call the affectation doctrine, which is things having a substantial effect on interstate commerce. That is a short phrase, but it breaks down into several different doctrines. So let me begin with one. Dr. Levy talked about economic activity versus inactivity. That, and I think this debate that you'll see before the Supreme Court, is framed around rhetoric. We need to break away from the rhetoric and get down to the doctrine, the constitutional doctrines at hand. Economic activity versus inactivity, that's a framing. Inactivity is activity. And let me show you. For instance, and there have been mandates. The idea that this mandate is unprecedented actually ignores the fact we have mandates. We have selective service, right? Those of you, male, 18 years old, are required to register for selective service. We've had required vaccinations. We've had school attendance that's mandatory. Those are mandates. And if you want to say simply for breathing, because that's how this is framed, those are mandates simply for breathing as a male individual, 18 years old. It's a mandate even for children breathing, right? Mandate for vaccination, which is also linked to schools. So the history of mandates actually is in existence. It's not this new thing. The other thing I want to invite us to get away from is the rhetoric. It seems to be a very guttural reaction we have. Oh, they're making us do this. It's the idea, I think, that we have to the idea of socialized medicine. Well, socialism seems like a dirty word. And it may be so, maybe ideologically, but if we get away from the ideological guttural reaction and come down to just the constitutional principles at hand, it does fall under commerce. For instance, speaking of the activity and the inactivity, what's being framed as inactivity? Dr. Levy himself said consumers deliberately decide not to purchase insurance. What's being regulated is the economic activity, the decision-making of when you purchase insurance, how you purchase insurance, whether you purchase it up front or whether you purchase it later, how you provide for medical services up front or later. That is an economic activity. That inactivity is activity in of itself. Now, why the regulation? Of course, Dr. Levy's done a great job of explaining the free rider problem, and we all know accidents happen, right? This is all grounded about healthy people. I think the outrage is if I'm so healthy, I decide I don't need the insurance. Those of us who thought we were Superman at 5. Do we still think we're Superman now? I put to you, no one is Superman. And even Superman isn't Superman. Superman will not know when kryptonite is going to fall. So unless we have a magic cure and a guarantee, that would make this debate more persuasive, but we don't have that. Now, there are some cases that I'll talk about to compare with the idea of what is and isn't commerce. We've had United States versus Lopez, which Dr. Levy had talked about, and that was the idea that Congress tried to ground gun control into commerce. The court rejected that idea, and the reason was it's too attenuated. You have to build inference upon inference upon inference. I don't think anyone here can deny that you have to make all these inferences to say health care equals money, right? This debate is all about money. The states don't want to pay money. Individuals, for the individual minimum provision, they don't want to pay money. Nothing can be more economic than money. It boils down to money. So that's the difference in Lopez, as well as United States versus Morrison, in which Congress also, it was invalidated. Congress was trying to regulate violence against women, and it had the Violence Against Women Act. Well, again, inference upon inference upon inference. But Dr. Levy already explained to you how the health care, or lack of health care, affects all of us. And so there are the inferences upon inferences that existed in those two cases. Another case that is relevant in the idea of inactivity versus activity is Heart of Atlanta. If you recall, Heart of Atlanta was about discrimination. Can we require the hotel owner to admit African Americans into the hotel? And the court said, well, this is commerce. It affects interstate commerce. Well, that was a guy who wanted to be inactive. Congress regulated inactivity. You cannot deny, if you are running a hotel or a place of public accommodation, you can't deny access. So we, again, have the activity going on. So moving away from the economic versus inactivity, let's go to the substantial effect. That's the second problem. Let me give you the cost of health care, just an average. 1 day in intensive care is $2,400. Herceptin for breast cancer is $37,000 a year, just to give you a contrast. And chemotherapy, arthritis medication, 43% of the drug budget for Medicare Part B is going to go to that. I already feel weakness in my bones, so I think I will be contributing to that. But unless we have a magic bullet that ensures we never need medicine, even preventative medicine, that we're not going to have accidents, that we're not going to get sick, the economic activity versus inactivity is not a winning argument. And because of that, it has a substantial effect. So, what is the substantial effect? Dr. Levy already talked about that. That when people get sick, they might not be able to afford their health care. They might file bankruptcy. That cost gets passed on to creditors, which then gets passed on to us as consumers. We all carry the weight of that problem. Let me talk about some more points that he had talked about, which is, it is unprecedented. Several points of that. The fact that it is unprecedented does not equal invalidity. Right? Unprecedented means we haven't gone there yet. But Congress has authorized a certain amount of authority. Because it hasn't exercised it at its benevolence doesn't mean now it is invalid. Also, we have ideas of the case of first impression. That's what unprecedented means. And we've seen cases of first impression. So that doesn't mean invalidity at the outset. All right, let's talk about celery and exercise. I don't like celery, and I definitely don't exercise. Am I fearful that if we allow the individual minimum provisions that I'm going to be forced to eat celery and start exercising? My husband might be happy. I might be healthier. But that's not a fear. It's not a fear because all those things implicate an individual liberty interest. There is no individual liberty interest to be free from economic regulation. So, at the heart of the matter is commerce. And at those tests that I talked about, they've all been met. I'm going to reserve some of the time for Professor Pujol, and then we'll take up some other points.
Well, I'll just use the remaining time to talk about the necessary and proper clause, since we've had such a excellent analysis of the Commerce Clause issue. And with necessary and proper clause, I already gave a hint when I talked about Chief Justice John Marshall in McCulloch v. Maryland. But ask yourself why we even have a necessary and proper clause, right? If we take Dr. Levy's argument at face value, right, that if the power is not specifically enumerated in the preceding part of Article 1, Section 8, we wouldn't need a necessary and proper clause. But to understand the purpose of the necessary and proper clause, we just have to go back to our own history, right? The Articles of Confederation, when Congress not only did not have a power to regulate interstate commerce, Congress didn't have any implied powers either under the Articles of Confederation. And to make a long story short, right, it was a very politically and economically unstable time. We tend to focus on the Revolution, right, and George Washington's successful military campaign. But after the Revolution was won, there was a lot of problems, a lot of trade barriers, a lot of protectionism, a lot of economic problems. That one of the reasons why, and this is my point here. Look, our founding fathers were were Federalists. They were not anti-Federalists. They wanted a strong and energetic national government to solve national problems. That is our limiting principle. If you don't trust the electoral process to deal with the celery hypothetical, well, unless celery somehow becomes a national problem, right, it's simply not within Congress's power. Now, and as I was saying earlier, right, the controversy over the national bank really is a rehearsal of the controversy over the individual mandates or minimum coverage. Now, I'll close by saying that ever since McCulloch, right, ever since that leading case involving the necessary and proper clause, it's really an axiom of constitutional law, right, that Congress does have power to solve national problems. And that's why we have the necessary and proper clause. I'm going to give you a brilliant example of this that I learned from Judge Richard Posner. Think of Congress's power to raise and support armies and navies. Nowhere in the Constitution does Congress have the power to create and regulate an Air Force. And yet, that's why the framers, our founding fathers, in their wisdom, inserted a necessary and proper clause to give Congress the national leeway. If members of Congress, our elected leaders, really believe that an Air Force is necessary for our national defense, necessary and proper, then they have that leeway, they have that deference as long as they pass the rational basis test. Now, and later in the debate, we'll talk about the mechanics of the rational basis test. So I just want to say that, because these free rider problems are national in scope, clear that Congress does have the implied power, if not the express power, to pass the mandate.
Thank you very much. Before we go back to Mr. Levy for his rebuttal, I just wanted to ask the members of the audience to be thinking of questions that you would like to put to these panelists. Write them down and pass them to the aisles so that we can pick them up and we can speak to them. So don't forget to write down questions that you would like to hear as we continue this debate. We'll go back now to Mr. Levy for 7 minutes of rebuttal.
There are quite a lot of things to talk about. Let me start from the last thing that was raised, and that is unprecedented does not mean invalidity. Well, I certainly agree with that. Unprecedented does not mean invalidity. But what it does mean is that there are no precedents that exist that control this situation. So if something is unprecedented, then you cannot say that Wicker v. Filburn governs it. You cannot say that McCulloch v. Maryland governs it. By definition, it is unprecedented without precedent. We are told that the Commerce Clause covers anything that involves money. And then the framers take the trouble to include in the Constitution a congressional power to coin money. After all, if the Commerce Clause was plenary and covered everything involving money, this is a surplusage of words, and even Chief Justice Marshall told us that we should not presume that any words in the Constitution are without meaning. We would not have meant, and we would not have needed the power to coin money if the Commerce Clause was so broad. We are told that we cannot have judges stepping in and overriding the wishes of democratically elected legislatures. That is nonsense. Federalist 78, Hamilton, quote, "A limited constitution can be preserved and practiced no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void." Madison shared this view. Quote, independent tribunals will be an impenetrable bulwark against every assumption of power from the legislative or executive. They will be naturally led to resist every encroachment upon rights expressly stipulated for in the Constitution. We are told that there are lots of other mandates, for example, vaccinations and the Civil Rights Act, the Heart of Atlanta Motel, and the Selective Service, taking those in reverse order. The Selective Service system is not authorized under the Commerce Clause. It's authorized under an express congressional power to provide for arming the military forces. Second, vaccinations. They are required by the states, not by the federal government. If vaccinations are authorized, it is to prevent injury to other people. And those injuries, by the way, are not injuries that are artificially created by government itself, as in the case of the mandate, with the mandates pre-existing laws to cover pre-existing conditions, and the law requiring hospitals to offer emergency care to all comers. But what about the Heart of Atlanta Motel? No one is required to open a motel in this country. The mandate applies to every resident of the United States, not just people who are in the motel business. Now, I need to go back to the really threshold question, and that is, what is the limiting principle? In the D.C. Circuit, when they argued this case, the government could not identify any mandate to purchase a product in interstate commerce that would violate the Commerce Clause. So what is the limiting principle? What can't the government order us to buy or to do, and why not? If the limit is based on the uniqueness of healthcare, then Congress, of course, can mandate the purchase of nutritional foods, exercise gear, force me to join a gym, sign up for Weight Watchers, and on and on. That's all healthcare related. If the mandate is based on the integration with a comprehensive federal regulatory scheme, as we've heard just a moment ago, then Congress can force me to buy bread in order to subsidize wheat growers. If the mandate is based on preventing some people from imposing costs on others, like they do when they get uncompensated emergency care, then Congress can force me to work, because if I don't, that imposes costs on others. Congress can force me to buy credit card insurance and mortgage insurance. If the mandate is mere timing, as we've heard, if it's all about the advance purchase, then the feds can mandate insurance coverage for death, for burial costs, for home damage, for auto damage, and on and on. What about the distinction between activity and inactivity? Judge Silverman in the D.C. Circuit wrote this, and you heard it echoed by my opponents. No Supreme Court case has ever implied that Congress's Commerce Clause authority is limited to individuals who are presently engaged in an activity. Well, that's what he wrote, but he's got it exactly backwards. The very nature of the Constitution is that all things are prohibited unless they are permitted. The Constitution sets out express powers of Congress. Those are the powers Congress has, and if the power is not listed there, Congress doesn't have it. Judge Silverman seems to believe that anything that is not expressly barred is permitted for Congress to regulate. Healthcare is unique, we hear. Everyone is a consumer at some point. Everyone is also a consumer of food, of clothing, of shelter. Can the government mandate how, when, and where those products are purchased? Unlike food, clothing, and shelter, most people actually consume very little health care. Mostly because they consume health care when they're older and they're already covered by Medicare at that point. Moreover, it is not consumption that causes the problem. It is the failure to pay. And very few people fail to pay. Most people insure voluntarily. Many people self-insure, and they pay when the service is rendered and when the bill is due. We should not be vesting the sins of the guilty on the innocent. And if we are told that healthcare is unique, every product is unique in some sense. So once again, what is the limiting principle? If the government can mandate the purchase of health care, what cannot the government order us to buy, and why not? In the Florida case, the appellate judge wrote, and this about sums it up, I'm quoting, "We are unable to conceive of any product whose purchase Congress could not mandate under this line of argument. The individual mandate is breathtaking in its expansive scope. It regulates those who have not entered the healthcare market at all. It regulates those who have entered the healthcare market but have not entered the insurance market and have no intention of doing so. It confuses those who presently consume health care with those who will not consume health care for many years into the future. The government's position amounts to an argument that the mere fact of an individual's existence substantially affects interstate commerce, and therefore Congress can regulate all of us at every point in our lives. That just about sums it up. If the insurance mandate is upheld, no limiting principle will constrain the federal government from doing whatever it wants, whenever it wants, to whomever it wants, and it is time to restore some semblance of constitutional government.
All right. Keep those questions coming, and we will now turn to our faculty who have combined 7 minutes to present the opposing view.
All right, several points, and then I'll share some time with Professor Pujol. The selective service vaccination, that is to the heart of the argument by the opposition about inactivity and mandates. Mandates have existed, and that I'm not debating vaccination or precedented or unprecedented, but the idea that that should not be an obstacle in this discussion here. And in fact, as Mr. Primrose had introduced, actually the idea of this has germinated since the 1960s. So whether it is unprecedented is perhaps still debatable. Should it matter? Absolutely not. That's the court's job, is to look at that which is unprecedented. The injuries being created by Congress versus the individuals that Dr. Levy talked about, the injury is a national problem. It isn't Congress that creates illness that befalls us. That is human nature. That's not a problem that Congress has created. It is a problem that Congress is trying to resolve. Now, getting back to a quotation that Dr. Levy had said, that the government has never required purchase on the basis of lawful residence. It still hasn't. It's not on the basis of lawful residence. It's on the basis of grieving. It is the decision that's involved. And Dr. Levy suggested, well, perhaps maybe there might be other alternatives, such as community service for those who need it. Well, one, I'm not sure whether that is a viable alternative, because if you are in a condition where you need emergency care, I don't know if you can do community service, but that's not for me to figure out. It's for Congress. The alternatives that are being suggested are the alternatives by us, unrepresented individuals, putting our decision-making in the place of Congress, and that's Congress's role. Rational basis guides Congress. It is the lowest level, the most deferential. Whether Congress wants to take 2 steps backward, 1 step forward, and 3 steps forward, it doesn't matter. As long as it gets a little bit closer to its goal, the court has given deference. And so rational basis is easily met here. Whether it is over-inclusive to include healthy individuals, again, that's the prerogative of Congress under rational basis. Rational basis affords Congress to be over-inclusive, including more people than necessary, or under-inclusive, not including as many as it should have. And that is the role for Congress to make. The other point that I'd like to talk about is to address the fear. Will Congress make us work? No. We've got the 14th Amendment. We've got the 13th Amendment. Servitude, right? We can't be forced to work. And so Dr. Levy, as well as the opponents, asked, well, what is the limiting principle? Don't let these parade of horribles get in the way. The limiting principle is just this. Is there a liberty interest being affected by the individual mandate? And I say no.
On that theme also, let me ask the same question of Dr. Levy. What is the limiting principle of his untrammeled view of judicial power, right? Think about the very facts of this case. Hours after this bill was passed by Congress and signed into law by President Obama, right? Dr. Levy and Paul Clement, people challenging this law, literally ran to the courthouse in Pensacola and submitted their complaint with Judge Vincent, with the clerk. You know, think about it. Is that really what the founders had in mind? You know, that every time a law which a small public interest group doesn't like is passed, they can circumvent the democratic process, politics, elections, and hope to get rescued on some kind of artificial act, omission, distinction that's nowhere in the Constitution? I have to say, as much as I think this law may not be a perfect law, I'd really rather trust the political process over the judicial process and give judges basically carte blanche to decide what laws are constitutional or not. I think I'll just close there, and we'll say more about some doctrines and intentions.
No. All right, thank you. We'll turn now to the audience's questions. The first question is for Dr. Levy, and it says, your argument seems to disregard that the Affordable Care Act was enacted by Congress, our duly elected representatives, and implies that President Obama has enacted this law as some sort of dictator. Considering that a similar law was approved by Mitt Romney as governor of Massachusetts, how much of the opposition to Obamacare is really politically motivated opposition to President Obama in general?
I'm sure there's opposition to Obamacare that really was opposition to President Obama, but that's not the source of my opposition. Romneycare in Massachusetts comes under state law. States are not subject to the enumerated powers proposition in the federal Constitution. The federal Constitution limits the power of the federal government, and that's what constrains, the Constitution constrains, not the judges, but the Constitution itself, constrains the power of the federal government. And when the federal government exceeds the power that's laid out in the Constitution, it is the job, as a matter of fact, it is the duty, the obligation of the judiciary to bind the legislative and executive branches with the chains of the Constitution. This is not a political matter. This is a constitutional matter. Of course, we also had legislative majorities enacting segregation in the South. We had legislative majorities enacting bans on interracial marriages. We had legislative majorities saying you couldn't have a gun in your own home for self-defense in Washington, D.C. All of these were properly overturned by the courts. The courts have an obligation to step in and require that the legislative and executive branches abide by the dictates of the Constitution.
Does the other side care to respond to that, or would you like to make a question?
No.
Okay. Again, reading a question that came from the audience for either side, so we'll give it to this side. Doesn't the mandated health care program cover the government, since the government is required to provide for the health, safety, and welfare of its citizens? And doesn't it say something when we are the only industrialized country that does not have a universal health care program?
So I think it does, but the other point I wanted to make about, not only is our country the only one of the rare countries that don't have a universal health care program, the reason we need it is that other states have tried some form of universal health care. For instance, states like Kentucky and Washington and New York, they had tried to provide health care insurance by eliminating denials on pre-existing conditions. And what happened was that the insurers, because they are mobile, migrated to other states that don't have this mandate. And so with the suggestion there are other things that can be done, actually other methods have been tried. And not that Congress has to, in fact it doesn't have to on a rational basis, but it has. And so I think this does get to the recognition of Congress that it is our responsibility to provide this, because the states on an individual basis was unable to, and the recognition that affordable health care is important to each of us.
May I comment?
Yes, sir.
Quickly on that? Just a quick note about this, the notion of rational basis, which we keep here mentioning over and over again. Rational basis does apply to the question of whether the regulated activity has a substantial effect on interstate commerce. The rational basis does not apply to the threshold question of whether this is the kind of activity, or in the case of Obamacare, the kind of inactivity that can be aggregated under the substantial effects test of the Commerce Clause at all. That's where the rational basis test applies. As to what else could have been done, there are all kinds of things. Single payment for Medicare would have been constitutional under the taxing power. Not under the Commerce Clause, but under the taxing power. Obama couldn't pass it. We also should have a right to opt out. That's been proposed by a liberal professor at Princeton University. Written agreement to forego the benefits if you don't take out your insurance policy. Higher premiums for those who enroll late. We could have had that. Denial of coverage for specific conditions for a short period of time, right after the policy is purchased. Lower premiums for young people, lower premiums for healthy people. Encourage automatic enrollment by employers in health insurance. There are all kinds of things that could have been required and could have been substituted for this mandate, but were not.
We have 1 minute.
Yes, you can respond to that.
So the ultimate question, I agree with the ultimate question, who decides that? Do we want a committee of lawyers in Washington, D.C. or a judge in Pensacola, Florida deciding that? Or do we want our elected officials to make this decision? And if they make the wrong decision, right, isn't it up to us as citizens to elect better officials?
And I want to add to that. Actually, there are a couple of points in this debate, which is one, is a Commerce Clause power. Even if it's not a Commerce Clause power, it's a taxing and spending. Taxing and spending allows Congress to use what legitimate means it has to get at what might otherwise be illegitimate or unauthorized ends. And I'll give you an example, South Dakota versus Dole. You can't tell states how to regulate, but you can hold a carrot. So the means was legitimate, and it then legitimized the end. And so even if you don't agree it's commerce, the taxing and spending would be also another powerful argument for Congress to exercise.
The spending power is about coercion of states. It's certainly relevant to whether the federal government can demand that the states expand Medicaid. It has no relevance at all to the individual mandate, which is about coercion of individuals, not coercion of state governments.
A slightly different approach by a member of the audience for either side. Does the mandate violate any individual rights? We've heard about the Commerce Clause and necessary and proper clause, the taxing and spending clause. Someone's asking about the Bill of Rights.
Do you want to respond? Well, and that's the point, right? What's being asked is, what is the limiting principle? The individual rights aren't implicated. It just sounds so bad on the enforced state salary, but there's no individual right being implicated here. And so that's the distraction. The fact that it sounds so bad. I'd like to invite Dr. Levy and others who oppose it. What is being implicated here? There's no freedom from contract. After Lochner era, that's going to change.
What's being implemented is the limitation on the federal government exercising only the powers that are enumerated in the U.S. Constitution. If you want to look at this, by the way, as a rights issue, I think fundamentally it's a powers issue, but you can look at it as a rights issue. Our most fundamental first principles are at stake, and that is for the government not to be able to compel us to engage in commerce so they can exercise, so they can regulate us because we are engaged in commerce. We limit government power so that the people can live their lives the way they want to. So this is not just an academic exercise to map out the precise contours of the Commerce Clause or the necessary and proper clause. I think that's a worthy endeavor, but it is just a means to achieve the goal of maximizing human freedom. And that is why we allow government to exist. We do not want government telling us how to live our lives, what products we must buy, and what limits there are on government's activities are dictated by the U.S. Constitution.
If I may add in reply, there's not necessarily, right, mutual compatibility between liberty and regulation. I mean, if there's one thing, again, I've learned from Richard Posner, is a wonderful paper by George Stigler entitled Wealth or Possibly Liberty. The paper, written by a libertarian economist at the University of Chicago, offers a stinging rebuke of this Hayekian vision that, all regulation is necessarily that. If we just look at this practically, right? We live in one of the wealthiest, if not the wealthiest country in the world, and we're also a heavily regulated country. Ask yourself if you, in your own individual lives, have more liberty options. Maybe, in some cases, in spite of the regulation, but in some cases, because of the regulation. All we're arguing is that it's up to elected officials, congressmen and congresswomen, to decide when regulation is liberty enhancing or liberty distracting, not judges.
It is indeed up to elected officials. The only limitations are those imposed by the Constitution, which the judges then step in to enforce. If the legislative branch or the executive branch exceeds the powers that are allocated to us under the Constitution, the judges have to step in. They've done it over and over again. We've had some 1,200 laws thrown out by U.S. judges. I must say I haven't looked at each and every one of those laws, but I would be willing to bet that human freedom has been optimized as a result of the loss of those laws, and we would have had less freedom had those laws continued to exist.
All right, we're going to have 2 more questions. Here's another one. What actually are the legal differences between penalties and taxes?
It's a matter of semantics. It's tomato versus tomato. There is no difference in the labeling of it. The tax and penalty has been used throughout the history of this healthcare provision. And so what we've got to do is we've got to go back to the basics. Could Congress have raised our taxes by $500 each? Yes. Can it use the tax then to pay for medical care or health care? Yes. That's what this is. This is a tax.
Yes, Congress could have taxed us, raised our taxes by $500. Yes, it could have used the money to pay for Medicare. No, that is not what it did. It imposed a penalty for not buying an insurance policy. In the legislation, it said that it was going to impose a tax for not buying an insurance policy. Wiser heads in the Democratic Party stripped the word tax and substituted the word penalty. There's a difference between a tax and a penalty. A tax raises revenue. A penalty punishes. Obama had promised over and over again to the middle class, there will be no new taxes. He understood that what he wanted was not a tax, but it was a penalty. And that is why only one court out of about a dozen that have looked at this have considered this to be a tax rather than a penalty.
May I respond? I don't know if it's fortunate or unfortunate that we don't fall within the top 1% of the tax bracket in which it was threatened that they would be taxed. Ask them if they wouldn't consider that tax a penalty. Tomato, tomato.
I would add one point. Dr. Levy's bringing in President Obama's statement, this is not a tax, totally irrelevant, right, to what Congress's intent is. What we care about here is whether Congress exceeded its powers, right? And part of the answer to that question is whether this is a penalty or a tax. Really, bringing President Obama into this is not helpful. I will say, though, that whether this is a penalty or a tax, we really think that under the rational basis test, Congress does have the pre-existing power to issue this mandate.
All right. One last question, and it is, never before has Congress forced people to enter into a contract with a private company. How does this mandate get over the mutual assent requirement? Sounds like this came from a first year. How does this mandate get over the mutual assent requirement in forming a contract?
It's really, I think, a very fundamental and important question. And the answer to it is, there is no mutual assent when the government is one of the parties. The government is the only entity authorized in our system to use force to coerce its citizens to do things that they do not want to do. There is no mutual assent. The government gets over the mutual assent problem by compulsion. That's exactly how it does it, and that's how it's communicated. respect to the individual mandate.
You should say in fairness, right, all laws coerce, right? And part of the price of living in a civilized and a free and democratic society is that we have to obey the laws, and laws we don't like. We can either take this judicial activist view and ask judges to repeal laws we don't like, or we can follow the political process. As far as this mutual assent, it's a good question, but I would add, right, Congress is here trying to solve a problem, right? Since there is no pre-existing right to freeload, there's no existing right to transfer the cost of medical care onto the taxpayer or onto the government. The question really is one, is this reasonable? Is it rationally related? Not whether this is the best policy or a good policy, right? The judicial question is this rationally related? It's the test that Chief Justice John Marshall gave us so long ago, and this mandate clearly passes the test.
And one, I want to compliment you and your contracts professor. I'll pass the word on if you were paying attention. My response is two things. One is Lochner error. Recognize freedom of contract. That you can't have these New Deal principles that limit the wages or maximum wage, maximum hours law. That's been abandoned. The idea of contract and freedom from government intervention of contract is gone. We have a recent example of this. In Johans v. Livestock Marketing, the government compelled people to pay $1 per head of cattle. And that then was used to advertise. And it's for the existence of cattle. So the cattle were being taxed for living, right? And you know what it was for? Eat beef, right? Eat more beef. So we can be persuaded to eat more beef based on Johans.
Right. Well, in closing the debate, I would like us to thank our panelists. We acknowledge that we each have about 9 minutes to get to this 6 o'clock class, and we'll be sure to let you out in time. Thank you for coming.
I just want to, thank everybody again for attending. This is the second annual debate. It's with the 1Ls and 2Ls that are in the room that this tradition can stay alive. So if you liked either of the arguments here, I suggest you get involved. I'm the president of the Federalist Society. Leanne's the president of the ACLU. If you think you attract more to one side, please come and speak with us and get involved so that next year and 5 years after that, this debate can stay alive and students like you and students in the future can continue to open up your minds and hear both sides of the issues. But I do appreciate everybody for coming, so thank you.